So this panel, welcome everybody again. This is our second panel on international law and course. This time with particular focus on Mr. Bello. We have 4 speakers in this panel, including David Hughes from Osgoode Law School at York University, who has worked for the UN High Commission for Refugees, the Council of Europe, as well as NGOs in Europe and Israel. Secondly, we have Ezequiel Heffes.
That was very well pronounced.
Okay, thank you. From the University of Buenos Aires in Argentina.
Yes.
Yeah, right country, good. Who will present a paper on the establishment of courts in non-international armed conflicts, Habeas Corpus and Lawfulness of Detention by armed opposition groups in the light of Serdar Mohammed. Next up, we have from the University of Southern Denmark, Amelie Theussen, whose research interest lies in the areas of new wars, law of war, Utopia, terrorism, organized crime, and she will present on how we classify contemporary armed conflict between apology for state behaviour and Utopia for Humanitarianism. And finally, from the University of Nottingham, we have Richard Watkins. Richard has previously studied at the University of Passau. He has completed an LLM in International Human Rights Law at the University of Nottingham, and he has a prestigious fellowship in the Arts and Humanities Research Council, and also recently awarded Dean Moore endowed postgraduate prize, which is very impressive. So he will present a paper on protecting soldiers from risk to their lives under Article 2 of the Convention. So each speaker has approximately 50 minutes, and I will leave my slides quite vigorously if you're going to. So take it away.
So stop means
Stop. Yeah.
Just make sure I'm working this way. Okay, so it's nice to be in Liverpool. Thank you very much to the organizers of this conference. It's been a busy but rewarding couple of days. So my research generally is on the diplomatic uses of international law within the Israeli-Palestinian conflict, how international law is used as a strategy or within the conflict. I look at both, I look at various case studies, one of which we'll be talking about today, but all of which relate to the use of law, particularly by state actors, the Israelis, the Palestinians, the Palestinian Authority, to a lesser extent Hamas, and to the international community, broadly speaking. Today I'm just going to be focusing, though, or I'm going to be prominently focusing on Israel's use of international law in relation to the 2008, 2009, and 2014 wars in the Gaza Strip. So throughout their shared histories, the Israelis and the Palestinians have engaged in tremendous violence against the other, and in no aspect of this conflict has the use of force and the resulting occurrence of such violence been more apparent than in the Gaza Strip. The succession of wars that have occurred in the Gaza since 2008 were presented by Israeli officials as acts in self-defense, perhaps not surprisingly, and I think relates to some of the earlier conversations we're having against the use of force and non-state actors. But Israel very much grounded its arguments in the use of force, and they presented it on in response to the amount of rockets that have been targeting Israel from the Gaza Strip, largely by Hamas, not exclusively by Hamas. Here you can see a little bit of a chart of the amount of rockets that were striking areas in the south of Israel, particularly the city of Sderot and communities around there. So when Israel began its offensive against Hamas, Operation Gaslight in 2008, it immediately presented clear views, clear justification for the use of force. Following 8 years of virtually uninterrupted rocket attacks, Israel asserted there was less than no other option than to respond in self-defense. During and after the war, Israel came under a great amount of international criticism from civil society groups, from states, from human rights organizations. And they were constantly accused of acting disproportionately, of targeting civilians within the war. The death tolls were quite high. And overall, it was quite a tragedy. But nevertheless, Israel, despite being constantly accused of violating international law, something that has been proven to be the case in a number of opportunities, they have nevertheless granted a lot of their arguments within international law. So before beginning the attacks, Israel noted, based on the principle of necessity, dating back to the Caroline affair, that it had pursued numerous non-military efforts to try to stop the violent attacks, including urgent appeals to the UN Secretary General, successive presidents of the Security Council, as well as diplomatic overtures directly into interviews. As a result of what they deemed to be international inaction, responding to the rockets, Israel claimed it was left with no choice but to respond in self-defense. Israel communicated that under international law, Israel was entitled to take military action to stop the thousands of deliberate rocket and mortar attacks that had killed or wounded Israeli civilians, threatened or terrorized hundreds of thousands more. Israel is a sovereign state with a moral and legal obligation and an inherent right under international law to protect its citizens from terrorism. So while emphasizing the collective effects of the 8 years of rocket attacks that preceded the first war in Gaza, and a purported desire to dismantle the requisite infrastructure that led to the launching of attacks, Israel was able to present an identifiable, or what it claimed was an identifiable objective directly linked to the desired security outcome. In so doing, Israel relied on the Tavish decision, declared its full commitment to achieving its objective in conformity with international humanitarian law, which was explicitly accepted by the Israelis as the appropriate legal framework governing the conflict. As a little aside, that might relate back to some of the conversation. Israel was quite adamant around the start of the Second Intifada about changing the governing security framework from one of law enforcement to one of IHL. So they very much welcomed the imposition of international humanitarian law on the conflict in this, in relation to the security situation and the threat of terrorism. And that's something just to keep in mind as we go through the rest of this presentation. So I want to specifically, just because we don't have too much time, I researched looks at a whole bunch of different issues in Bello. But I wanted to specifically talk about one military operation that occurred during the 2014 war in a Palestinian and Gaza neighborhood called Utopiya. You can see the top left of the map there. It is a neighborhood, almost a suburb of Gaza City. 92,000 residents live within 6 square kilometers. It's one of the most densely populated within the Gaza Strip, which is one of the most densely populated areas on Earth. So you can imagine there's just quite a few people in a small landscape that's dotted with large multi-story apartments. So the urban features of the neighborhood, coupled with the nature of asymmetrical warfare, meant that any significant military operation by the Israelis in this neighborhood would bring almost inevitably a heightened risk to the local population. Yet during the war, during the 2014 war, between 19 and 20 July, CGB became the target of a large aerial bombardment and one of the largest uses of force that the conflict has seen since probably 1967. So Israel is faced with quite a dilemma. How could they achieve this operation, which I will explain in a second, they deem to be quite important to their overall military objective? How could they do this and at least provide some kind of conception of compliance or respect for IHL? And proactive engagement with many of the indeterminate dictates of international humanitarian law did seem to provide Israel a means of achieving a military objective that would otherwise appear kind of vastly incompatible or at least in significant tension with a humanitarian-centric system of civilian protection. So that's just a picture of the neighborhood. You can get a sense of how sort of densely populated it is. Obviously, numerous people live in all of these different apartments, and finding and accurately striking legitimate targets within this landscape would be particularly difficult. So on the day that the attack commenced, the IDF, the Israeli Defense Forces, asserted that since Hamas had gained control of Gaza in 2007, Utopiya had become a stronghold for terrorist activity. The neighborhood was said to be saturated with Hamas observation points, home to a vast network of tunnels used to attack Israel, rocket launching sites, significant weapons caches. In just under 2 weeks, preceding the war, the IDF claimed that Hamas had launched over 140 rockets at Israel from this neighborhood specifically, And the planned military objective in this neighborhood was placed within the contextual objective of the overall operation, which was, of course, to curtail Hamas terrorist capabilities and infrastructure. Incidentally, was deemed to be essential to the safe likelihood, again, of any significant military action affecting the civilian population in quite a diverse way, as well as the associating condemnation that Israel would inevitably received, remained quite specifically. Days before the commencement of the military action, Israel began to issue warnings to the local residents to evacuate and move towards the center of the city. Here's an example of a warning leaflet in Arabic translated into English. Basically says that you have until a specific time to get out and get to the center of Gaza. Israel presented this as a detailed example of their efforts to conform with the principle of distinction as an attempt to balance border civilian protections with its need to avoid undermining the military attack. Further public communications that were sent out widely to diplomatic missions throughout the military demonstrated numerous locations within the neighborhood of IDF terror sites. That's defined somewhat broadly, but you can get a sense of it right there. So there are areas where rockets have been fired, so it's launching grounds or weapons caches, identified or housed terrorists, were designated as combat posts or entry points into tunnels that were used to attack Israel. Okay, so I'm going to skip ahead a little bit. You can see more examples here of some of the material that the IDF produced to sort of demonstrate the threat that the state would cause. And then the attack happened, and just to give you a little bit of an idea of what the neighborhood looked like after the attack. It was largely total. This is footage from a drone that was flown above it. So the neighborhood was really decimated. A huge amount of artillery was dropped on the neighborhood. The international community, in response to this specific attack, got quite upset. The EU statement was fairly representative. While recognizing Israel's legitimate right to defend itself against any attack, the EU underlines that the Israeli military operation must be proportionate in line with international humanitarian law. So we have this idea of international law that we talked about just as recently as the last presentations. And I think Joran Finstein's quote that LOAC in its entirety is predicated on a subtle equilibrium between two diametrically opposed impulses. Military necessity and humanitarian consideration is an issue that's at the tension of a lot of these examples of uses of force. So the way that Israel chose to engage both strategically and diplomatically with international law gives an example of what David Kennedy sort of describes as the way that international law can facilitate conflict and can facilitate violence, especially international humanitarian law. So we see, and we often come across this idea of gray areas, right? Because so many of the legal provisions that are commonly relied upon, concepts like proportionality or distinction are inherently vague. So Daniel Reiser, the former head of the IDF's International Law Division, which is a division within the military that handles both decisions, everything from decisions of targeting to determination of when uses of force are appropriate, talks about how the gray areas can really be exploited. Skipping ahead a little bit, we have this idea, again, going back to this tension between the humanitarian and between military necessity. One sort of principle that Israel took from the community established to review the NATO bombing campaign of the ICTY was the idea of the human rights lawyer and the military commander, and it's probably quite true, that when making assessments about military advantage and ensuring injury to non-combatants, the military commander and the human rights lawyer are going to come up with probably very different conclusions as to what constitutes proportionality, what constitutes distinction, what is a legitimate military attack. And Israel, as is the case with many different militaries, of course, complies the standard of a reasonable military commander, which provides quite significant latitude And Israel has looked to effectively and advantageously use international humanitarian law. So the former defense minister of Iraq said we cannot change the law, but we can help develop it. Masak Asher, the author of the IDF's Code of Ethics, talked about the more often Western states apply principles that originated in Israel to their own non-traditional conflicts in places like Afghanistan and Iraq. The greater the chances these principles have of becoming a valuable part of international law. What we do becomes the part. What we do becomes the law. So there's this idea that Israel has quite often pushed internally, is that international law, international humanitarian law specifically develops through its violations. So we talked about targeted killings today, and a lot of people looked at the Israeli model when the US was beginning to adopt targeted killings in other parts of the world. So just to conclude a little bit earlier than I had intended to, we see this idea about international law as what's meant to be a constraint on violence. But oftentimes we witness international law as being used as a means to facilitate violence. And oftentimes the question about this, like what David Kennedy recognizes, is this idea that international law is used by militaries to legitimize the use of force, to legitimize violence as a public relations tool. And I think we need to look beyond that framework. I think he's right, and I think there's a lot of examples of that, but I think it's oftentimes too limited of a framework to look at it. And what we see is this notion of when states engage with the use of force, and this is by no means exclusive to Israel. We see this example of international law being used in a specific way to essentially to increase through its violations. So I think the idea that what we need to look at IHL is this notion of what really is our trump, like where we want to put our emphasis on what we can permit under international law or what we can try to stop under international law. So I'm going to just stop there. Thank you very much.
So next up we have Ezequiel Heffes from
Yes, Ezequiel. Thank you very much, and I don't know if you can hear me well without the microphone. Is it okay? Yeah. So firstly, of course, should I get it? There's so much. Like this? Yes. Thank you, the organizing ILHRU, for giving me the possibility of being here today, speaking about detention in non-international non-conflicts. So the aim of my presentation is actually to discuss what's the legal basis for detention in non-international non-conflicts, particularly for those detentions made by our opposition groups. I should clarify first that this is under my personal capacity and in any way entail the responsibility of any institution. Having said this, generally speaking, I mean, there's 2 years ago, in 2014, May 2014, there was this decision here in the UK by the High Court of England and Wales, deciding that the UK lacked of authority under international humanitarian law to detain individuals in a non-international conflict in Afghanistan. And according to Justice Legat, the legal detention after the person is detained, therefore mostly related to the treatment of the person under the power of one of the parties to the conflict. This decision was held in 2015 by the appeals court here in the UK, and now is pending the decision of the Supreme Court here as well. In the appeals decision, it was also affirmed that neither Common Article 3 nor Additional Protocol 2 or customary international humanitarian law as sources of international humanitarian law in non-international conflict provide a legal source to detain in non-international law. So again, the statement was related was actually aimed to find the legal basis for these detentions in domestic laws of states, and therefore the UK was not able for detentions in a non-international law. The aim of this presentation is actually challenge these statements, these decisions. From a legal perspective, there are several difficulties that finding the legal basis in domestic law may entail, such as, for example, what happens in extraterritorial spillover, NIACs, or what state acts abroad for extraterritorial non-international conflict. So what would be the legal basis for the detention of that state in a third state territory? And for example, it was not explained that the situation of international human rights law for those states also acting abroad. So when I thought about this was why not IHL? I mean, and this is the aim of the paper is actually link the basis of detention with the administration of justice by the parties to the conflict, particularly by the armed groups in non-international conflicts. So IHL nowadays in Common Article 3 and in Additional Protocol 2 recognize that the parties have certain obligations regarding the administration of justice. So Common Article 3 states explicitly that the parties should not pass sentences or judgments without, sentences without a previous judgment by a regularly constituted court. Additional Protocol 2 in its Article 6 also confirms the judicial guarantees that detainees may have. And the interesting part is Common Article 3 and Additional Protocol 2 apply both to states and non-state parties in the conflict equally. This is based on the principle of equality of belligerents, which affirms that all the parties in NIACs have the same rights and obligations regardless of the reason why they are conflict. So when we think about the international humanitarian law obligations that the parties have regarding the establishment of a judicial mechanism or this regularly constituted courts, one may think, for example, that, of course, when we think about states, it's normal that we think about the judicial power of the state, but if international humanitarian law obliges both states and non-state actors, particularly armed groups, should be able also to constitute a judicial system run in parallel with the state judicial system in order to fulfill these obligations provided by IHL. This is, I mean, some a part of the doctrine actually argued that the basis for the constitution of these judicial tribunals, of these judicial bodies, can be found only in states' domestic legislation. But in my opinion, if we look to this principle of equality of belligerents, which affirms that both states and armed groups have the same legal obligations, we should be able also to look at at possible armed groups' internal codes of conduct or internal laws in order to assess the existence of possible of a legal basis for the constitution of the judicial mechanism. And this is very interesting because there are several examples in which armed groups have claimed publicly and have actually passed laws, internal laws, explaining and confirming a legal basis for the creation of a certain body of law that, of course, depending on the organization of the group, might be similar to one of the state or less organized, but it still is a legal basis. So this is, I mean, for example, why do I say this? Because as I said, there are different offers. For example, it comes to my mind that the customary study of the ICRC in 2005 said that regularly constituted court, in terms of Common Article 3, should be understood as based on the domestic law of the state. In the Hamdan case in the US, the dissenting opinion of Justice Alito also said that the legal basis for these regularly constituted courts should be found in the national law of the state. So these positions, in my opinion, that do not represent what the principle of equality of belligerents states in non-international conflict. So if we confirm that legal basis for the creation of these tribunals for armed groups. And both armed groups and states can create established judicial bodies and pass judicial decisions. The aim why do I link this with detention in non-international conflict? For me, it's like when actually we had the decision saying that it was only the domestic law, the legal basis for detention. This, of course, implied that armed groups could not detain anybody, at least not legally, because they would be automatically in breach of the domestic law of the state. If we think about it, so we have the domestic law of the state saying that only state authorities can detain people in general, and of course in non-international conflicts. Therefore, no other entity fighting against the state will ever be authorized to detain members of the state armed forces, for example, for the purposes of the conflict. So what's the link between this lack of authority to detain by armed groups and the creation of these judicial bodies? I believe that there is a link between the possibility of the detainees of challenge the grounds of their detention before judicial bodies and the lack of an authority of detention in ILHRU, as mentioned by the High Court of England and Wales here and the appeals here also in the UK. So if we go, for example, in order to be fully respectful of the judicial guarantees enshrined in Common Article 3 and in AP2, a person, a detainee, should be able to challenge the ground of their detention. And this, with respect to in the SCP recognized in Article 9, as one of the possibilities is, for example, habeas corpus. So why, if we say on the one hand that an armed group doesn't have the capacity, but doesn't have the legal authority to detain under ILHRU, and when detaining, is automatically in violation of the body of law, which is domestic law. How a court of an armed group will decide when a detainee challenges the ground of his or her detention before that court? If it's already in violation, in principle, that detention will always be arbitrary, and it will not find a legal basis because it's already in violation of the domestic law of the state. So this is what I believe it's sort of a contradiction between the argument that relies on the domestic law as a legal basis for detention in NIACs and the link with habeas corpus, or with the right to challenge the reason of detention or the grounds of detention by the detainees in non-international conflict. I have to admit that habeas corpus as such is not a right recognized in ILHRU. However, the Inter-American Court of Human Rights, in two advisory opinions, number 8 and number 9, has recognized that the habeas corpus is essential to respect all the other judicial guarantees. And this is the same has been recognized by the Human Rights Committee in the General Comment 1929. So even if the habeas corpus is not recognized in IHL, neither in Common Article 3 nor in AP2, an argument could be built with respect to the other judicial guarantees enshrined in Common Article 3 and AP2. And it's quite interesting also if we see the practice of armed groups, because there are some internal codes of conduct and some internal criminal laws of certain armed groups recognizing right of challenging of the detainees. So it's simply to analyze that this might be a contradiction. So we have an armed group with an internal law establishing a legal basis for a tribunal. And that law might be, for example, determining the procedures that the detainee could follow before that tribunal. So that person could formally challenge the ground of detention before that court of the armed group. The legal basis for that detention is found in domestic law of the state. That court will never be able to decide on an IHL basis, or will never be able to decide that detention was lawful, because that detention as such is in violation of the domestic law of the state. However, if the detention in non-international conflicts are regulated by international humanitarian law. That court and that person who's challenging, that detainee who's challenging the ground of detention, will be able to have his detention as such, his deprivation of liberty, reviewed by that tribunal. Either arbitrary or non-arbitrary, but that's going to be decided by that tribunal. Otherwise, it's always based on the domestic law and the domestic link with the state, which of course in non-international conflict is quite complicated because the non-state actor is in principle violating the domestic law of the state by the mere fact of fighting against the state. So just to summarize and not to expand any more on this, I believe that there are different arguments that can justify or can provide a legal basis for detention in non-international conflict, which are based on international humanitarian. One is the right of detainees to challenge the ground of detention, and this can be found in the code of conduct or in the internal laws of the armed groups. And to be completely respectful of the principle of equality of allegiance, the practice of armed groups should be taken into account. Also, for the ends of engaging these groups in the respect of international humanitarian law. I believe international humanitarian law is the legal basis for detention in non-international law. Thank you very much.
Thank you very much. So let's move on to Amelie, who's representative on the classification of contemporary armed conflict between apology for behaviour and utopia of humanitarianism. So,
thank you very much. Well, I also want to use the opportunity to say thank you to the organizers to begin with for organizing such an interesting conference, and to the rest of you for still being here and hopefully sticking with us for the last two panels. So my name is Amelie Theussen, and I'm based at the University of Southern Denmark, but right now I'm actually a visiting PhD researcher at Durham University, so I'm just a train right away, which is quite nice. And I'll be talking about the classification of contemporary armed conflicts between apology for state behavior and utopia of humanitarianism. And I'll actually touch upon quite a few things that have been mentioned here and there, I think. So it's not going to be super new. That's just the content for the next few minutes. So I probably can skip the first part almost, the traditional legal framework of IX and IX. We've taught that a lot now. But then I'll walk you through Koskini's argument about the indeterminacy of the legal argument. But I'll do that very briefly, and I probably won't do him justice, to be honest. But yeah, 15 minutes. Then I'll talk to you about the areas of misfit or perceived misfit that exists between the legal dichotomy and contemporary armed conflicts, and then how this misfit can be overcome. So what are the arguments, the legal arguments that are brought forward? And that's here where you see the apology and the utopia of the whole thing. And then hopefully I'll manage to reach my conclusion in time. All right, well, we have international and non-international armed conflicts. International conflicts between states, that also accounts for occupation, though, and for wars of national liberation under Additional Protocol 1. And we have non-international armed conflicts, which are between a state and a non-state actor. And there is this clause of in the territory of one high contracting party that's caused quite a bit of stir. And we have Additional Protocol 2, which kind of creates a second, more specific type of NIAC under IHL. All right. Let's see. I hope that wasn't too short, but I guess most of you know what I'm talking about. Well, when we come to Koskini's indeterminacy argument, he basically argues that for international law to be objective and thereby independent of politics, it requires both normativity and concreteness at the same time. But the problem is that these two requirements actually cancel each other out, and one can also be used to criticize the other. So in a way, it creates a circle where you can't really get out. Because concreteness is meant to refer to the closeness of a particular rule or to doctrine or state practice, particular rule or doctrine to state practice. So it's very important to link to the state. States actually use it. How do they use it? But the problem here is that the closer to state practice it is, the less normative and the more political it also becomes. So in a way, taking it to the extreme, it becomes an apology for state power. On the other hand, we have normativity, which intends to demonstrate the distance to state will and state practice. But the other problem here is that the more normative we become, the more subjective it again becomes, depending on your own ideas of what is right, what is law, how should the world work. And thereby it becomes utopian and also manipulable at will and political. So we have this problem that both of these aspects are inherently political. And thereby law, especially international humanitarian law, can be criticized for being political really no matter what. Either as an apology for power or as an unrealistic utopia. And the cost community basically argues that the only way we can get out of the circle is by making some sort of choice. Of course, political meant in this broader sense. So what does that mean for the classification of armed conflict? All right, well, a lot of you, I'm sure, have heard about the whole war and terror thing, what type of armed conflict that is, and the fact of transnational armed conflict, that's a huge problem. But there's actually several areas where there's discussion going on as to how to classify this type of armed conflict. So if we start with international armed conflict, which is usually the most straightforward type of conflict, we have the question whether there can be occupation without military presence, especially relating to Gaza. And this basically just shows you the impact that technology can have, and with drones and border controls and all these kind of things. I'm not going to go into answering these for you because I only have 15 minutes, but if you want to hear more about them, grab a cup of coffee with me afterwards and we can discuss it. Regarding non-international armed conflicts, I divided it in a few steps, as you can see. So first of all, we have foreign intervention by an outside state. And then on the side of the state or against a non-state actor, it's not quite the same, but I'm putting them in the same category here. And the central aspect here is really consent. So if consent is given by the territorial state's government, there are a few different views, but most would agree that that then constitutes a non-international armed conflict. But we still have this problem with the territory clause, so in the territory of one high contracting party. And a few argue that that only refers to internal armed conflicts, and that's kind of the traditional view that was held. So some argue that that would necessitate a new type of armed conflict, a new legal classification. Others, on the other hand, argue that it should be classified as an international armed conflict because it actually crosses the state border. But the Israeli Supreme Court, for example, in the targeted killings had that position, but it was widely criticized, but it's not completely dead as an idea. So the situation changes a bit if there's no consent given. Because then what we have to look at is whether the non-state actor is actually controlled by the territorial state or not. Because if it is controlled by the territorial state, it would be an international armed conflict, which could be determined by either an effective control test or an overall control test, depending on whether you go for stricter requirement of state responsibility or just what Tadic case sat as a test for the internationalization of an armed conflict. But what happens then if the non-state actor actually acts independently of the territorial state? And there are three views. So the first view would be that it depends on who you target. So if you target the non-state actor exclusively, it would be a non-international conflict. If you target also the wider infrastructure, it would be an international armed conflict. The second view is that there would be a sort of a dual armed conflict. So we have an international and a non-international armed conflict running in parallel. And the third view would be, again, that this is a completely new type of conflict and we need a new legal regime for that. So then against the territorial state on the non-state, on the side of the non-state actor, we basically have two views. So either an internationalization of the conflict happens, that the non-international conflict turns into an international armed conflict through either the crossing of the border or through direct intervention or through the non-state actor acting on behalf of the foreign state. Or we have the view that it's a dual armed conflict happening actually, where we again have these two parallel armed conflicts running. But again, there's no agreement here. I mean, it's widely debated. But it seems to me, at least, that the key thing is the link between the non-state actor to the intervening state. Because if there's a link between the two in terms of this effective control or overall control test, then internationalization is pretty certain to occur. But if there's no link, then it seems to me that it's probably a dual-arm conflict. But it's still very, very much debated. As a last point, we have interventions by multinational coalitions, and there's key whether we have UN authorization or not. If we don't have UN authorization, everything I just said applies. If we do have UN authorization, it depends on the effective control, whether the UN has effective control. If it does, there's a question. Is it an international conflict because of the nature of the UN, or is it a non-international conflict if the UN is fighting a non-state actor, but an international conflict if it's fighting a state? Still very much discussed. All right, now that you know what all the problem is, there are actually a few ways in the literature, well, for legal arguments basically given how to overcome this misfit. And this is here really where you can see utopia and apology happening. I've kind of summarized it under 3 themes, but I have to say that they're not mutually exclusive, and you will see that they're all kind of sort of connected, actually. So the first theme would be solving it via customary law. And on the Utopia, well, we obviously have the ICRC customary law study from 2005 that found that a lot of the rules applicable in IX also apply in IX. For the Utopia side of the argument, basically, people took that and said, look, what's happening here is a unification of the legal regimes through customary law. You know, that's what we're going for, right? We want to support this because that then does not allow political manipulation anymore. It doesn't allow the use of the classification of armed conflicts as a political tool because we will have one set that applies to all armed conflicts, no matter what, including the gray zones that I just talked about. But on the apology side of things, basically, scholars argue that, well, that's all nice and pretty, but it doesn't work that way because fundamental differences actually remain. For example, combatant status and the prisoner of war status, which are quite essential in international armed conflicts. And they actually criticize the ICRC for having its own agenda and for pushing, you know, everything just a bit too far. So they basically argue that it might be that the study they made is more the law like it should be instead of the law how it is. For the second theme, we have this idea of a new legal regime, where we, for example, on the apology side, obviously have the US after 9/11 claiming that to their conflict with Al-Qaeda, IHL actually doesn't apply because it doesn't fit either IAC or NIAC categories, which will clearly be a reduction of the protection. So that, of course, has been heavily criticized, but been quite widely spread that if, the idea has been widely spread that if we come to have a new legal regime, the protections might actually be minimized. And additionally to that, it's very unlikely because states just plainly don't agree. And an additional problem is that it's difficult to create something that would fit all these gray areas that I just talked about. On the Utopia side of the argument, we also have to strive for a new legal regime, but with the goal of increasing the protection, actually. And they argue that increasing the protections and tailoring it to particular situations of these gray zones would increase the compliance of IHL as well, because unsecurity about when to apply what would actually be reduced. The third theme that we can identify in regards to arguments how to overcome the misfit is state practice. And here we have on the sort of apology side of it, we have the argument that states are reinterpreting the NIAC regime to apply externally. So instead of focusing on the territory, they actually focused on high contracting party, so it would include all states. And we also have states which actually started to apply the rules that apply to international armed conflicts to non-international armed conflicts. But they maintain the clear distinction between the two regimes. So they actually they state quite obviously, okay, we're implementing IAC rules in an IAC context because we're actually worried because we're not quite sure which one we're supposed to use, so we're using the better one, so we're not doing anything wrong in a way. And you can find in the literature that comes out of pragmatism, at least that's what's being argued, and on the apology side of the argument, that for the education of soldiers, for the simplicity of the guidelines, and the retainment of the traditional framework, this basically works for them. However, for the scholars that tend more towards using the Utopia aspiration of continuous framework, this actually is a sign of a humanitarian commitment and an increasing humanization of international humanitarian law. And also move towards the individualization of the protections and away from state sovereignty. All right. And again, to come back to the beginning for unification of the legal regimes. So in this, you can actually see kind of the dynamics of military necessity and the humanitarian concern play out as well. So to conclude, what I was trying to tell you in very confusing words, I'm sure, there is no agreement in the literature and there's no uniform practice. It seems to me that the most promising for some sort of agreement is either the unification via customary law, because we do have the ICRC customary law study that showed promising advancement there, or actually a reinterpretation of the existing framework so that states can actually make do with what we have. And my conclusion for my dissertation in this is that we actually need case studies of different armed conflicts where we analyze the practice by states and other relevant actors, so not only looking at the apology side of the argument, to look at how they classify these conflicts in these specific situations, what are the underlying reasons and why it works, so that we can actually determine the extent of the problem.
Thanks very much, Amelie. So finally, we have Richard Watkins from the University of Nottingham with a paper entitled New Positive Application, Protecting Soldiers from Risks of Their Lives under Article 2 of the Convention. Take it away, Richard.
To Ben and Patrick for organising this conference. It's been fantastic. It's been a privilege to sit and listen to so many fantastic presentations. My presentation is about how to protect soldiers' right to life, and it's a bit of a worthless platitude to say that they have the right to life. What we have to do is identify legal standards that courts use to ensure that the right to life is actually being guaranteed by states, and that's what I'm going to do today by reviewing some of the case law of the European Court of Human Rights and looking at a case study of British soldiers killed in Iraq. So in 2013, the Supreme Court of the UK handed down its judgment in Smith and Defence, and this judgment concerned a number of joint appeals arising out of Iraq. And there were two sets of claims, the challenger claims and the snatch claims. The challenger claims were brought in negligence of common law only. The snatch claims are going to be interested in today because they concern the soldiers' right to life. Those claims arose out of soldiers who had been killed in detonations of improvised explosive devices, IEDs, and their next of kin claimed that the state take the reasonably practicable measures to protect them from being killed. So the facts in a little bit more detail. During the occupation, there was an explosion in the town of Amelie in southern Iraq, and a patrol was sent to investigate that blast. And they were deployed in snatch Land Rovers, which are lightly armoured vehicles that were first procured for military operations in Northern Ireland. They can withstand small arms fire, but not the effects of bomb blasts. Now, these vehicles haven't been fitted with any electronic countermeasures, which are electrical devices that can block radio signals and prevent the detonation of IEDs. These vehicles didn't have any of them. An IED was detonated. They weren't able to prevent the detonation, and 2 of the soldiers were killed. Now, 7 months later, a patrol was sent out again in snatch Land Rovers from the Iraqi police headquarters in Al-Amara to the nearby British Army base. They were travelling in a convoy of 2 snatch Land Rovers, escorted by 3 heavily armoured warrior tanks. So to some extent, the army had learned its lesson. And those snatch Land Rovers had been fitted with the electronic countermeasures, but there was a vital component that actually made them work that was missing. It was sat in the base, waiting to be retrofitted. And an IED was detonated, and 2 of the soldiers in that patrol were killed as well. Now, the judgment in Smith was not a judgment on the merits of the claims, it was all about the Ministry of Defence's application to have the claims struck out completely. As far as the human rights claims are concerned, the government contended that the soldiers were outside of the jurisdiction of the United Kingdom for the purposes of Article 1 of the Convention, and the state was not bound to uphold their convention obligations. Article 1 of the Convention provides that the high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in the Convention. Now, the European Court of Human Rights in Australia, United Kingdom, defined the jurisdiction in a really expansive way. It's not just about having effective control of territory, it's also about state agents exercising authority and control over an individual. Lord Hope in the Supreme Court indicated the legal judgment in Smith said that by virtue of the command structure and the culture of obedience and discipline that's inherent to the British Army, British soldiers are always within the jurisdiction of the United Kingdom, wherever they are in the world. So how do we guarantee their right to life once we have ascertained that they do actually have human rights when they're deployed abroad? Well, Article 2 of the European Convention says that the right to life should be protected by law and that no one should be intentionally deprived of his life. And Section 2 of Article 2 defines what have been called the law enforcement exceptions, which state the deprivation of life shall not be considered as inflicted in contravention of this article, where it results from the use of force which is no more than absolutely necessary in defence of any person from unlawful violence in order to effect a lawful arrest or an action to quell a riot or insurrection. In the text arising out of Article 2, it is primarily negative. It's an obligation to refrain from killing. But the European Court of Human Rights has inferred a positive obligation as well to take positive steps to protect individuals from harm. The next of kin of the soldiers killed claimed that the UK failed to fulfil this important positive obligation. The general principle is that in certain circumstances, the state will be required to protect individuals from risks. And that doesn't necessarily mean preventing the risks from eventuating completely. Like someday, and it would be impossible to prevent that from happening. Although I'm sure there's some sci-fi film out there that will claim it's possible. The general principle is about taking what's reasonably practicable to prevent these risks from actually eventuating. The European Court has expressed in its jurisprudence a number of different expressions of how this can work. And the problem with all of these is that when you apply them in the armed conflict scenario, they just don't work. They're perfect for domestic peacetime law enforcement situations, but not in the armed conflict. So if we have a look at those cases now and see why they don't work, Osman and the UK is the seminal positive obligation case. And in that case, the European Court of Human Rights determined that the state was obliged to take preventive operational measures to protect an individual whose life is at risk from the criminal acts of another individual. Now, in that case, there was a school teacher who had become infatuated with one of his pupils. He did a lot of creepy things and eventually went round to his house and shot him and his father. The boy survived, but the father was killed. Now, the European Court judged that when the state knows or ought reasonably to know of a real significant and immediate risk to an individual from the criminal acts of the third party, they have to take reasonably practical steps to protect that individual. That means they have to protect them where they can, but they don't have to take any steps that require an impractical diversion of resources. So how do we apply that to this situation? Well, the first problem is criminal acts. Whilst this is okay in domestic peacetime, we know which criminal acts we're going to be trying to protect against. It was very confused to talk about criminal acts in armed conflict situations. For a start, the Geneva Conventions govern the conduct of hostilities in armed conflict. Attacks against civilians are prohibited. But combatants, soldiers, they can attack each other at will. It's not a crime. Obviously, there are restrictions on means and methods of warfare that they're able to use. But if we limit the risks that we have to protect against to those prohibited means and methods of warfare, that makes a really, really narrow obligation. Secondly, in a non-conflict situation that's going on abroad, there may be multiple different criminal regimes applicable. In the snatch land rover situations, British soldiers, they're subject to British military law. They're operating in Iraq, so there may have been some way of making them subject to Iraqi criminal law as well, and this international criminal law. How do we determine which criminal acts under which criminal law regimes we have to protect against? It gets really, really messy. And if you can overcome or overlook these flaws, which I don't think you can, it's still not really effective, because you need to have an identifiable victim. The European Commission said in W and Ireland that there's no need to provide enhanced protection to an individual when they're not specifically threatened. The soldiers in these snatch land rover cases weren't specifically threatened. They were targeted because they were British soldiers, just because they had a Union Jack on their fatigues. Really, they were just in the wrong place at the wrong time. It could have been any soldier sent out on that patrol. It could have been any road where the ID was laid. It could have been detonated at any time. There's no specificity to the threat at all. So there's a general duty to protect society at large, but that's a really, really low threshold, because it's going to require an impractical diversion of resources, which we don't have to do, in order to actually protect people from things that we can't define. As a comparison, when Prince Harry was serving in Afghanistan, there were specific threats against him because he was at the time holding on to the throne. That would have been quite good for the Taliban to get him. It was possible to provide enhanced protection for him. They just airlifted him home. But you can't do that for all soldiers, because then you can't fight the war. The next problem is you need an identifiable culprit. You can't protect against someone if you don't know who they are. Now, people who laid the IDs in these scenarios, we don't know who they are. They're enemy soldiers or insurgents or whoever, but we can't identify them and we can't protect against them. So it's clear from all of these problems that the Osgoode obligation doesn't work in our conflict situations. The standards that suggest the duty on the state to take protective measures aren't met. The court has also, the European Court has also said in Yildiz in Turkey that states are under a duty to govern the licensing, setting up operation, security and supervision of inherently dangerous activities. Armed conflict is an inherently dangerous activity, of course, but we can't do anything to prevent those risks without changing the military role and function. So what can we do? The general principle of Article 2 is protecting people. But how can we protect the soldiers? The current expressions of the positive obligation are what the court has developed in their jurisprudence in their decided cases, but it's by no means an exhaustive list. There's room for a new expression of the positive obligation to create a legal standard by which we can assess whether states have fulfilled their obligation to guarantee their soldiers' right to life. On the basis of the general principles in the court's jurisprudence, states should be under an obligation to take reasonably practicable measures to prevent unjustifiable increases in the risks to soldiers' lives. Now, there is a persistent background risk to soldiers all the time whilst they're deployed abroad. They can be targeted at any time, and this risk is enhanced to different degrees in different situations. For instance, when out on patrol or when manning a vehicle checkpoint or in the heat of battle. These increases can't be wholly planned for or predicted or prevented, but states must not increase the risk without justification, so they must take reasonably practicable steps to prevent the increase. But how does that work in practice? Well, there's a background risk to our soldiers. There we go. Whilst they were on deployment. And then, whilst they're in the base, there's this general background risk to them. If they're attacked in the base, that's the safest place for them to be. They're walled in, they're heavily defended, they've got supplies of food, water, equipment, ammunition, and they're in numbers. As soon as they leave the base, that risk increases. Because they're not surrounded with all the things that they can use to protect themselves. If we send them out in vehicles that can't withstand bomb fire, then that risk increases yet further. And again, when those vehicles aren't capable of preventing any IEDs from detonating with ECMs. So in this situation with the smashed land claims, it looks like there has been an interference with the right to life. Can we justify it? In the circumstances, we might say that they probably should have been sent out in more heavily armored vehicles that could have protected them against the bomb blasts. But if we look at these situations in isolation, that's very easy to say, but they were happening at the same time as lots of other different military operations with competing priorities. We can't give these soldiers the heavily armored vehicles if that means taking them away from other soldiers who need them more in their own situations. Human rights law is not about creating some utopia that's completely divorced from reality or context. It's about creating fair and realistic obligations on states that are capable of being upheld. We ought to say that these soldiers' right to life, or we ought not to say, sorry, that these soldiers' right to life was violated just because they weren't in a Challenger tank. We have to be realistic. As long as the military commander can show that the allocation of material and equipment was done according to an objective assessment of need, considering the availability of equipment and the difficulties establishing supply lines, then in the first situation, their right to life is not violated. In the second, however, the equipment was there and ready and available to be fitted to the vehicle, but it wasn't. And there's no justification for that at all. So in that second situation, we would say that their right to life had been violated. Now, a couple, very, very quickly to conclude, a couple of obstacles to protecting soldiers' right to life generally. It could be said that military commanders will start being overcautious. We don't want to over-judicialize the conduct of hostilities, but the framework that I've discussed today also would require judges to get themselves involved in things that people think they probably should keep their noses out of. Military objectives, commanders' operational decisions about the deployment of forces on specific missions, and the allocation of equipment, and government procurement decisions as well. But I do think this is a realistic way of trying to protect soldiers' right to life in our country.
We have around 10 minutes for general comments and questions, so if you'd like to question. We start from Michelle.
Sure, thank you very much. Thank you all. Really engaging, excellent set of papers. Many of the speakers were really well actually, and panel as well. Seems like some useful conversations going on between the papers. A question for Richard directly, and then a more general question. Your paper has allowed me to jump on my favorite two polemic hobby horses, my over-distrust of my ILHRU at the body of law, and my skepticism about human rights, its involvement in our conflict. And it's, I guess we talked about judges should keep their noses out in the sense of these are not big decisions that don't know about a conflict, but I wonder if there's not another reason why judges should keep their noses out. The decision, the tort dimensions, the domestic tort dimension, even the domestic human rights decisions, so the Supreme Court decisions on this, I don't have so much of a problem with. But when it comes to European Court of Human Rights, I have a real issue with European Court of Human Rights making human rights-based decisions to soldiers, British soldiers on. And I just wonder whether or not there's a way of thinking about this with the European Court of Human Rights by arguing that British soldiers have the right to life ought to be better protected in military situations. Probably not, is the European Court not involved in itself in an asymmetric conflict at that stage? It's certainly not capable of giving protections to Iraqi soldiers, for example. And what I think many of the other papers have demonstrated to us is that ILHRU wants the European Court of Human Rights to examine ILHRU in a textual sort of basis, what is military necessity and so on. We know that in practice, conflict is ILHRU is constantly derogating from, and so on. So the European Court of Human Rights, by taking a very literal application of ILHRU, sort of engaging in conflict, in my view, on the side of the British soldiers to an extent. The second question is an even more rambly one, which, so I have in mind when Catherine was speaking about ILHRU, and then Dave took it really made it explicit, and then when Amelie, when you spoke about having used for case studies, I thought Dave explained and demonstrated the need for case studies, and Catherine's probably as well. And I think you made a very good point though, because I wonder to what extent IHL, when we use IHL as the examination tool, we're missing the entire point. We need to examine how states go about conflict. And to that, on that point, I wonder whether, particularly more working, whether you've and yours did, whether you've examined the sort of intent behind conflict. So we talk about proportionality, we talk about necessity and so on. But one thing that the drone use of drone strikes demonstrates is the way in which the US government, following on from the Israeli government, have sort of got this schizophrenic view of intent now. You can, if you don't intend to kill, as long as you have that split sense of intention, and I wonder to what extent that's a general question for anyone doing anything with drones.
If I go first, thank you for your question. Yes, that is the problem with the inequality that we have the same sort of protections to direct soldiers as well. It's difficult because obviously the Iraqi soldiers are shooting the British soldiers and the British soldiers are shooting back. I mean, the whole thing is that Article 2 gives you a negative obligation as well. The deprivation of life is not the intentional deprivation of life is a lawful except in those circumstances, which obviously can't apply in non-conflict either because they sort of directly undermine what conflict is. I don't see any reason why an Iraqi or the next of kin of a killed Iraqi soldier couldn't try to enforce his right to life against the UK, because by being killed by British soldiers, they would be within the jurisdiction of the United Kingdom. But I think that this expression of positive obligation that I've given today is specifically for a state to its own soldiers, as opposed to a state to soldiers of other states. Does that answer your question?
It does.
Yeah.
So on the issue of case studies, I think they're incredibly important and not done nearly enough. I was largely motivated by Abram Chase's work in the international legal process method, which really does focus on case studies, and that seemed to have its moment in the 70s out of the experience of himself and others in the Cuban Missile Crisis, and then just kind of disappeared. But I think it's a great way to look at IHL and one that's not done nearly enough. Our intent, unfortunately, one part of my presentation I didn't get to today, but the idea of intent, especially in relation to the principle of fiction, features hugely in Israel's legal engagements in relation to the wars in Gaza, and they very much hold the position that the principle of distinction, this fundamental IHL principle, is satisfied as long as they do not directly intend to target civilians. And I think it's not very often that a military would explicitly intend to target a civilian population. And through targeting decisions, through classification of who constitutes a combatant, the bombing in Gaza in the 2008 war, at the beginning of the war, of the police graduation ceremony, if anyone's familiar with that, really sort of shone a light on how combatants are defined within this framework. So I think like intention is really important to look at, and is very central to a lot of the more intricate Israeli arguments as they pertain to distinction, to targeting, to proportionality.
I can just add to that. I completely agree. In my case, I'm coming from political science and international relations, and we love case studies. And it's just struck me that it makes good sense to try this with the connection to IHL. As for the intent, I agree that it's crucial to look at that. Also, in regards to my work, because I will be looking at the intent of a certain specific classification, right? Why do we classify the armed conflict as we do what is the actor's underlying objective in that regard. So completely agree.
So we have time for one more question, I'm afraid. Anybody? Yes, yourself.
Yeah, for here. So one of the arguments that the British government used for the High Court of Appeal was that in this kind of internationalized NIAC, wrongly called internationalized NIAC, it had inherent authority by analogy to the rules of international armed conflicts. And I would like to hear your thoughts on that argument. Why do you think it's wrong? And whether this is yet another reason to think of unification of these two regimes, because it brings a lot of problems, practical problems.
Well, actually, it's I mean, just because I presume that they did it because in international conflicts you have explicit provisions regulating detention and regulating the reason of detention. So if you go to Geneva Convention, to the Third Geneva Convention, you have a specific provision regarding the detention of POWs. For me, I'm a bit more skeptical about the uniformization of the two bodies of law. I mean, I understand the goal to enhance the protection of the people in the field, but I essentially believe that because of the principle of equality of belligerents and because also we want to engage non-state actors in the respect of international humanitarian law, we have to take into account their practices as well, not only states' practices that are being used. So, yeah, I mean, it's a working process. And again, for me, there are many arguments in the law of non-international conflicts that can justify and give legal basis for detention. I mean, one is this, the possibility of the police challenging detention, but also it's also a military advantage issue. So it's like you detain someone because you take that person off the field of fighting against you. So it gives you a military advantage to actually detain somebody even better than kill that person. So it just, I mean, it's again, for me, already in the law of NIAC, there are a lot of arguments, but the difference between the law of NIAC and the law of IACS is that in international conflicts, the rules are explicit with respect to the grounds of detention. And this is not the case for NIACS.
Okay, well, thanks very much for all of the speakers, and for the audience for very interesting comments and questions. So we have a break until what time? 4. We break until 4. So if you'd like to leave the way to the social space for some refreshments, we reconvene here for this session. Okay, thanks very much.